Call Andrew Little.
Mr. Chairman, the issues in Part 2 of this bill are not extensive. It's a very important rewrite of crucial parts of the Domestic Violence Act, and in principle there can be no objection to that. This part of the bill and the changes that it makes to the Domestic Violence Act include, which the Minister seemed to have admitted in her comments, an addition to the definition of domestic violence to now include economic and financial or economic abuse as a new form of domestic violence. And I think that is there's justification for that addition, or at least a clarification of what constitutes a form of violence. The new or the redrafted provisions make a distinction between safety programs, which are programs for victims of domestic violence, and it also provides for programs, or what I call non-violence programs, for alleged abusers or those who commit violence or domestic violence. And as the Minister correctly pointed out, there is now a registration process for service providers. Mr. Chairman, the reason I wanted to take this call is just to make this point, which is not to detract from these elements of the bill, but to say that there is a real risk under the redrafted provisions, as in fact there is today, of the credibility of these provisions being undermined if the courts are not properly resourced to exercise its jurisdiction, or that is to say the District Court, not only in granting protection orders and making orders in relation to safety programs, but also their safety valve role in ensuring that objections to the granting of protection orders can be properly heard. And I simply want to relate the facts of a case that is known in New Zealand, and in fact known to the Minister, where a man who was the subject of a protection order following an altercation between himself and a former partner was then under police investigation for assault, was the subject of an application for a protection order without notice, which was granted. He was ordered to attend a non-violence program. There was a 10-day objection period, and because this was around Christmas time, he missed the 10-day cut-off. He says partly because of bad advice. In any event, he missed it. It was then 4 months before he could have his objection heard. By this time, the police had concluded the investigation into the alleged assault, found not only was no assault committed, but in fact the antagonist was the former partner, and she was held responsible for the altercation which occurred. And by the time his objection was heard, he was part way through the non-violence program, having been told that if he failed to attend, he would be subject to arrest. And he is still, to this day, waiting for the court's decision on whether or not the protection order was properly granted and he was required to attend a non-violence program. I might add, he has completed the program. He is a supporter of the Domestic Violence Act. He is a supporter of protection orders and the orders contained in the Act. But he has been dealt an unfair deal, been given a dirty blow because of the lack of resourcing of the courts. And this Minister, as the Minister of Justice, is responsible for that. She has to understand that if the courts are not properly resourced, then this sort of legislation which she sponsors will be not regarded with any great credibility. And the credibility will be undermined, and she needs the confidence and the support of the community for these sorts of measures to be properly supported and to work. And I simply say to the Minister, give us an assurance, please, that when these sorts of applications are being provided for, when people's liberties have the potential to be constrained, let us please have the judicial safety valves in place, properly resourced and able to deal with those sorts of objections. Because at the moment there clearly are people who are being treated unfairly, the victims of injustice, if those resources are not there in place. And this provision of the bill, these redrafts of these parts of the Domestic Violence Act, will be given scorn and derision if those safety valves are not put in place. And I simply ask the Minister to give us an assurance that people will not be treated unfairly when they are faced with these orders, these very important orders that are about securing people's safety if indeed the resources are not there.
The Honourable Phil Goff.
Mr. Chairman,